Welcome to Divorcelaw with attorney David Badanes.
Welcome to Life Changes. Court orders change. How to make modifications to your divorce decree. I'm your host, Abigail Vaca, and today I'm joined by David Badanes. Thanks for joining me today.
How are you doing, Abigail?
I'm great. How are you?
Very good.
I'm excited to have this conversation. So, my first question is, what are the most common reasons people seek divorce modifications?
Well, things change. We all know that during life, many financial things can change in your life. Many things with your children can change in your life. It's very hard to predict, especially if your children are young or whatever, what's going to happen either financially or with your children throughout the 5, 10, 15 years after your divorce. So that's typically the reason why people want a modification, whether it's financial or something to do with the children.
And how do changes in financial circumstances like a job loss or a significant increase in income affect spousal support or child support post-divorce?
Yeah, typically it's usually about child support. If one person, let's say the person paying child support, either gets an increase in income or or loses their job or decrease in income, either party, either parent can go to court and say, wait a minute, that person making much more money now, so they should pay more child support. Or the person paying child support says, wait a minute, I lost my job or something happened and I need to pay less child support. There's a lot of things you have to do in either of those situations to your attorney so that they're successful in either getting an increase or a decrease. It is certainly not automatic. And again, some of this depends on what your divorce agreement stated, because your divorce agreement could say that no matter what happens, we're keeping everything the same. Although there's an exception to that as well, but it makes it much harder to change if your divorce agreement says no matter what, and I'm using English terms, not lawyer terms, you're not going to be able to go back for an increase or decrease. There's always a catch-all or an exception, but then it becomes harder to get an increase or decrease. Versus most of the time, you can go for an increase or decrease every 3 years in child support, or if someone's income changes by more or less than 15%. And that automatically says I can at least go to a judge and say, wait a minute, 3 years have gone by, I should get more money or pay less money. Or, hey, I used to make 100,000, now I'm making only 80,000. That's 20% less, more than 15% less. I should pay less money.
And in the same vein, can child custody or visitation orders be modified after a divorce? And what factors do courts consider in making those changes?
Things change with children, obviously. They get older and things change in their lives. Maybe one parent wants to move, etc. Maybe one parent now has a full-time job and working in New York City, let's say, and can't take care of the children as much as they used to. Maybe the children say, hey, I want to live with the other parent. I want to see the other parent more, whatever. So there's always things happen in child custody that you can go back to court, again, depending on the circumstances of what is going on with the children's lives. Again, it's not an automatic. It all depends on what's the best interest of the children. Just because they may want to change, that may not be the best change. Just because you want to change doesn't mean you're going to get it. You have to show, why are we making this change to the court? Why is this in the best interest of the children and what they were used to?
So is it possible to modify a divorce settlement if one spouse believes that those original terms were unfair or inadequate in some way?
Well, not necessarily because you thought they were quote unquote unfair or inadequate. That's very, very difficult to show or demonstrate. It's more about, again, if we're talking about money, what changed in terms of people's funds and income. So that's really not whether, even if I agreed to something that you may think is unfair, or I think is unfair when I agree to it, that's not the criteria. The criteria is if you want to change, you agreed to pay that, and now why should I pay either less or more? So it's not really about being fair or unfair. And the same thing with custody. It's not about whether it was fair at the time you signed the agreement. It's what has changed. And that's what I always tell people. You have to show when you sign the agreement and at that time and now at this time, what are the differences? That's the key. You have to show what's a change or the differences between those two time periods, when you sign the agreement and now. So even if you sign the worst agreement in the world, yes, you can try to show that was unfair or whatever, but you signed it. Let's say everything was, wasn't like you had a gun to your head or something of that crazy nature. The judges do not like to say that it was quote unquote unfair. You signed it. That was what you decided to do. For modification, it's just, again, what changed.
That makes sense. And what role does the child's best interest play when modifying custody or support orders post-divorce?
Well, support order, almost very little. Okay, support, again, is based on the incomes of the parents. It's not about what the child may want or child thinks. It's really just, every kid wants as much money as they want, so to speak, but it's really about income, okay? So it's not about the best interest when it comes to child support. But when it comes to custody, it's always about the best interest. So again, if you're looking for a modification, you have to say why whatever has changed, why is this more in the best interest? It could be as simple as mom or dad is moving and they, we don't want to take the children away, to California or whatever. It could be that, again, a new job. It could be because the kids are getting older and they want to spend more time with the other parent. So the best interest there, it is somewhat similar to what happened in the first case. Why the court will look at why, now that we're looking at this today, what is in the best interest of the children.
So can a parent request a modification of child support if their child's needs change? Like, let's say unexpected medical expenses come up or educational changes are needed.
The answer is yes, you can request it, but it could be a very tough hill to climb, so to speak, or hoop to jump over. Again, your agreements will say what they say in terms of who pays what. And of course, there's exceptions to every rule. So if there's a very large, let's say, medical expense, it certainly could say, wait a minute, this type of surgery or whatever is not covered by insurance. This was not anticipated. The other parent should pay whatever, half of it or whatever of it. It's very, very rare that these things happen, of course. But if there is a truly unexpected expense, you can go back to court. Educational, that would be much tougher. Medical, something's happening to the child and the courts want to make sure they're taken care of. But if you're talking educational, typically I'm guessing that maybe they want to go to private school now. Most likely you're not going to succeed. If they were going to public school, now you want to have the other person pay for private school. I never say nothing, nothing 0% chance, but very little chance that that's going to succeed. If you have a good agreement, which is, it should be taken care of. In terms of college, that all college expenses should be addressed in your agreements as well. So just because you want to go, even if the child's a genius and wants to go to Harvard, MIT, or anything that's a really great school, and it's going to cost nowadays, I don't even know how much that costs. I've heard numbers like $80,000. Court says, well, your agreement says that they only have to pay usually up to what state university pays. And I'm glad your child's a genius, but I'm not going to make the other party pay for it because it's very clear that they only have to pay up to what's called the SUNY cap, meaning up to a state university cost.
That's good to know. So my final questions are, what should someone do if their ex-spouse is not complying with the terms of a divorce decree? Can they request a modification or enforcement of the original agreement?
So yes, typically, and again, depends somewhat on your divorce agreement, but any good divorce agreement should state, because it is a contract. So just like any contract, if someone's breaching it, there's a way to go back to court and say, wait a minute, my contract says they're supposed to pay, I'll make it up, $500 a month in child support, and they're not paying it. There is usually a procedure that you should go to an attorney to make sure you do all the procedures. You go to the attorney will make sure they dot their I's, cross their T's, so to speak. And when you go back to court, it should be, pretty simple. Gee, it says here it's supposed to pay $500 and they haven't paid it. Those are, in a sense, somewhat easy case, except you want to make sure you do it the right way. So yes, in terms of enforcement, whatever says in your divorce agreement or any other court order can be enforced. It's not in terms of modification, just because I'm not paying the $500, in my example, $500 a month doesn't mean I should now get $700 a month. One has nothing to do with the other. So just because I am not in complying with whatever the court order says doesn't mean I should be able to modify things. So those are two different concepts.
That all makes sense. Thank you for breaking this all down for us today. It was a pleasure chatting with you.
You got it. You have a great rest of the day.
You as well. Thank you for joining us for Life Changes, Court Orders Change. Please be sure to like, subscribe, and leave a review on our channel.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.